So, Bob, today we're going to discuss the five Trump administration orders that have been issued with respect to law firms. There's been one involving Covington and Burling, one involving Perkins Coie, one involving Paul Weiss, one involving Jenner and Block yesterday, and then one a few days ago on preventing abuses in the legal system that was addressed to Mark Elias and his firm and some immigration lawyers. And I want us to focus on the ones against Perkins, Paul Weiss, and Jenner, because these are the most significant ones, and they've pretty much been the same in retaliation for some perceived past deed done by the firm or one of its lawyers against Trump, and on the basis of other allegations. These memos have barred these firms from utilizing, barred the government from utilizing the firm's services, suspended the security clearances of its lawyers, prohibited them from entering the federal buildings, and initiated reviews to terminate contracts with the firm clients, which may be the most significant thing. So basically, and this is the last thing I'll say before I turn it over to you, Perkins responded with a lawsuit, and it got an injunction stopping the enforcement of the EO. Paul Weiss settled. You wrote about that on Monday. And Jenner and Block responded yesterday saying it will take all appropriate remedies. So can you just tell us, where are we in this saga?
It's an escalation. It begins with Covington and Burling was the weakest of the ones. It involved stripping security clearances, but it was very focused on those in the firm who had purportedly helped Jack Smith. Of course, the representation of Smith began after he left the government, but nonetheless, the order holds these lawyers responsible and strips them of their security clearances on the basis that they were helpful to Jack Smith, who had, of course, initiated those prosecutions of Donald Trump. And then it progressed from there to the broader sanctions that you mentioned just a minute ago. And in the one in which Mark Elias and the Elias Law Group are cited as an example of unethical conduct by lawyers, it broadens the attack out because it has the Attorney General conducting ongoing monitoring of ethical misconduct by law firms and directs the Attorney General to take action both with the bar and in other unspecified ways, other appropriate actions unspecified in the presidential memorandum that was addressed on the Elias and immigration lawyer basis.
And can I ask you about that? Yes. On that point? To me, that last one was less threatening to the profession than the three that I suggested that we focus on. And the reason, and tell me if I'm wrong, is that threat turns on other institutions like the bar or courts ultimately doing something or against those firms and lawyers. Whereas the three, the Jenner, the Perkins, and the Paul Weiss orders, those go directly after the clients and the firm's business with the government and executes powers that the president himself can bring to fruition, rather than having to rely on other institutions, and immediately cut into the firm's client base and to the firm's operations with the government. So those three struck me as more threatening than the Elias one. What do you think?
It depends on how that is implemented. I mean, I think it's a loaded weapon sitting on a table at the moment. It is not clear how it's going to be used, and firms are going to be conscious that in any litigation against the government, they're facing this threatened and aggressive action. So I agree with you. In the immediate future, it is clearer to see how those concrete sanctions against Paul Weiss and Perkins Coie will operate to hurt the firms. But then there's a sort of broader threat that is being broadcast to the larger community, and how it plays out, I think, is still to be determined. It's a fairly extraordinary thing to have the Attorney General essentially operating as an ethical inspector general who is going to be deciding which of the lawyers in the firms that are opposing the government, appearing before executive branch agencies, have been engaged in vexatious or unethical conduct. And quite apart from bringing particular complaints to the bar, she's also authorized to take other appropriate action. It's not clear what that's going to be.
Yeah, fair enough. I didn't mean to suggest it wasn't extraordinary. It just seems like there have to be more steps involved there. Maybe they've got something up their sleeve that I'm not sure of. Whereas the three against the firms, these have immediate consequences for the firm's operation with the government. And my point was that the executive branch can, whether lawfully or not, there's an injunction with regard to one order. The executive branch can effectuate those implications immediately and go right to the core of the firm's business.
Yes, I agree with that. Absolutely.
And so you wrote critically on executive functions on Monday about the Paul Weiss settlement. Can you just kind of summarize what you said?
Yes, I mean, in brief, it seemed to me that this agreement was unwise, harmful to the profession. How it plays out for Paul Weiss over the long run is something altogether different. But Paul Weiss, in effect, entered into a 4-year partnership, at least with respect to some programs, some firm programs and responsibilities with the federal government. It now has a responsibility, for example, to reach agreement with the government on clients that will be taken into its pro bono program, whether its pro bono program represents a diverse set of views from liberal to conservative, whatever that may be, an audit that the government will be involved in helping to structure is going to take place of the hiring program of the firm, again, with the government being concerned with these diversity initiatives that it calls out as DEI, disfavored DEI programs. And we've never seen anything like that before. And Paul Weiss agreed to it. There's a view out there that didn't agree to anything more than it would have done anyway, that fundamentally it wasn't all that significant a concession. And I have to say, I disagree with that. I think the mere fact that it has entered into an understanding with the government that the government will have a role in its own self-governance in those ways is, I think, extraordinarily damaging to the profession.
And just why is it damaging to the profession to have, in effect, the government scrutinizing who, I mean, to ask the question is to answer it, but
yeah,
to in effect have the government scrutinizing which clients the firm takes and how the firm doles out its legal services.
Central to a firm's ethical responsibilities is maintaining professional independence. That's embedded in the values and, for that matter, even the express ethical obligations of the profession under, say, the model rules of professional conduct. And in particular, the bar is charged with self-regulating precisely so it doesn't become somehow an object of regulation of the government. It needs to keep its distance from the government. And here, that distance has been closed. It's entering into this pseudo-partnership, quasi-partnership with the government around these particular programs. Again, the language in the Weiss executive, or excuse me, the agreement between government and Weiss, the language is as mutually agreed on the hiring audit, for example, and on the $40 million worth of pro bono services. Those are going to be committed to initiatives as mutually agreed by Paul Weiss and the government. And that just conflicts with any notion of full professional independence for firms to make a decision who they hire, the clients they take on, and the clients that they reject.
So we should make clear, as you made clear in your story, that there's at least some question about what was actually agreed to, because the Paul Weiss version of what was agreed to and the president's Truth Social, or I think that's where it was, version of what was agreed to, there are some discrepancies. But I think your point still holds.
Yes, there are some discrepancies. I don't know how meaningful they really are. Stephen Gillers, my colleague at NYU, who is a renowned expert on legal ethics, takes the position that what we really have in this order is poor drafting. But that already is a problem, because poor drafting enables the government to make assertions about the agreement that clearer drafting would have avoided. And so this ambiguity works very much against the law firm. It invites the government once again to make demands, adjustments to prior understandings, just based on the fact that the language lends itself to various readings.
Yeah, so I just want to, so your colleague Gillers had a piece, I think it was in Business Week, I'm not sure where it was.
Bloomberg, yeah.
Bloomberg on this, in which he basically defended in pretty robust terms what Paul Weiss said. And I just want to walk through a few of those things. With regard to the $40 million in mutually agreed projects, he asked why this was objectionable. He said, perhaps the government shouldn't be able to tell a law firm how to devote its pro bono time, but would you litigate just to make the point? And I take it you would.
Absolutely. I don't see how a firm gives in on something like that. I mean, the firm's pro bono programs, like his general client representation programs, are an important element in the firm's self-definition, in how lawyers operate, the causes they're prepared to take on free of charge, as well as the causes they take on for pay. And so you litigate about matters, it seems to me, that are of high significance. I don't see how anybody could claim that the government becoming involved in those decisions is not a matter of high significance and concern to a law firm.
So Gillers made the point that, I'm paraphrasing and then I'll quote, that Paul Weiss's obligations weren't in the first or second or third instance to the profession. He said, and I'm quoting him, "There is a suggestion in the current debate that Paul Weiss was obligated to be brave for the rest of us, that it was required to fight Trump on behalf of the rule of law, and that its settlement was somehow a betrayal of some principle governing the conduct of private firms. That is not so. Paul Weiss's first obligation is to the courts that license its lawyers, then to its clients, many of whom have business or cases with the federal government, then to its staff of 2,500, and finally to its own survival." What do you think?
Here's what I think. Paul Weiss reportedly had revenues, or will have revenues this year, of close to $2.5 billion. If the question is that Paul Weiss should have done everything it could possibly do to preserve itself as a firm with revenues of $2.6 billion, then I'm sure the point stands. But how can that be? How can it be that the survival of Paul Weiss is going to be measured by the billions of dollars in revenues that it currently has, as opposed to what it might give up, maybe just at the margins, in litigating on a matter of fundamental professional principle and values? I just don't follow the survival argument at all. And I do believe that as a law firm, just as is true of individual lawyers, it has a responsibility as a profession to these basic principles. And so I don't think they're ones that are secondary to the considerations that it takes into account as a business organization.
Okay, let me zoom out a little bit. Do you think that there is a relationship between the attack on law firms through these executive orders and memoranda and the administration's attack on judges? I mean, are these part of the same strategy, or are they unrelated?
I would think, I'm interested in your view on this, I would think they're very related. I think the administration is doing whatever it can to weaken resistance to the program that it's attempting to implement. They came out of Trump 1.0 committed to making Trump 2.0 fully successful in the way that the president and his aides don't think Trump 1.0 was. And part of the problem they ran into in 1.0 were lawyers within the administration who put up objections to things that they wanted to do. Special counsels, of course, who brought on investigations that he found crippling and objectionable, and the courts. And their view now is they have to sweep these legal technicalities and concerns aside so that they can accomplish this extraordinary radical change that they're looking to make, articulated by people like the current OMB director, Russell Vought. This is a radical constitutional moment. They're going to restore a constitutional order that was superseded by a false one that we're now living under. I mean, do you think I'm overstating the case?
No, I think that, and we've both written in separate places and together, that it's clear that the Trump administration is trying to sweep away all legal obstacles to what it wants to do. It has done a very impressive, in terms of its success, job of doing that within the administration, in terms of ensuring that there's no legal obstacle to the president's will in terms of what gets done within the executive branch. It's clearly operating way outside the box and very dangerously, in my opinion, for its own self-interest in attacking judges the way it's been doing, and operating at the margins of, well, I wouldn't say at the margins. It's just operating like no other administration has ever operated there, and it's open, aggressive disrespect of judges and the judicial process. And obviously, these orders are designed to, among other, to punish. And as Trump has said many times, you hit back 5 times harder than you're hit, or 10 times harder, and you make sure everybody else is watching because it has a deterrent effect. And this is going to clearly is aimed to, in addition to punishing, to chill the profession from holding the president to account in court. It seems like that's the clear aim here.
Yes, and to, if at all possible, exercise some degree of intimidation directed toward the courts. And already they've moved twice to have judges removed from courts who've ruled against them. In Boasberg's case, in the deportation case, in Judge Howell's case, in the Perkins-Coie case, alleging that they're biased because they ruled in a way the administration objects to. One thing you pointed out, and I think this is going to be the moment where the perfect storm begins to materialize, is that they're pushing so aggressively in this direction that by any conventional standard, they're hurting their legal case. They're undermining themselves. But What happens when they've so undermined themselves that they hit a wall? Are we at that point going to find them taking the next step and saying, I don't care, for example, to the courts what you think, I'm going to do it anyway?
So that's a great question. I want to leave that one for another day because that takes us in another direction. Let me wrap up by asking you the biggest picture question, and that is, I mean, I don't know if you can even speak to this yet, but how does this end? How does the profession recover? This is a body blow to the profession, and it's happening from within the profession. These are lawyers inside the administration who are facilitating this. There are lawyers on sides of this debate that seem to be helping the administration. The president apparently reportedly called Bob Gifford, I think the managing partner or the head of Sullivan and Cromwell, I'm not sure, who has seemingly been helping the president in achieving his aims. How, if it ever, does the profession recover? What happens next? How does this end?
Well, to go back to Paul Weiss again, and I don't want to put the entire, sins of the moment on Paul Weiss, but the agreement Paul Weiss reached was a real blow to the profession being able to mount a concerted, unified attack on this. And as you know from press reports, there are indications that other firms are starting to think that maybe they ought to go the negotiation route here. And if you can divide and conquer in this way, it's not clear how the profession can recover. I mean, this could go on for 4 years. And we discussed at the beginning of our chat here, it's escalating. It's not as if he's stepping back. The first line of the Jenner and Block EO issued yesterday was, my administration is committed to pursuing the remedies against what he calls these risks of the law firms here, the risks entailed in the way the law firms have conducted themselves. So the absence of a unified front here, I think, is extraordinarily unhelpful.
And do you think that judicial remedies in individual cases like Perkins Coie secured, that injunctive relief in individual firm at the individual firm level, can that really protect the firm? Is that going to enable the firm to keep its clients and keep its business, or is that still a win for the Trump administration?
I think the Trump administration can pat itself on the back for some short-term win because it frightened the legal profession, and there have been obviously allegations or suggestions that Paul Weiss and Perkins Coie suffered significant losses to their businesses. But I also think that if the judiciary stands up here, I think we may see the boat turn somewhat. It may be a slow turn in heavy water, but I think we may see the boat turn somewhat, and other firms emboldened to think that they can actually push the administration back from the brink.
Thanks, Bob.
Thank you.